All right. Hello, everyone. Thank you very much for joining us today. My name is Tanya Bulakovsky. I'm a human rights officer at MENA Rights Group, and I am happy to welcome you to today's webinar discussion on the topic of the use of administrative counterterrorism and security measures used as a tool by state authorities to silence dissent across the Middle East and North Africa region, or the MENA region. These administrative measures can take the form of travel bans, citizenship revocations, administrative detention, or terrorism listings, and can be imposed outside the criminal justice system, stripping those impacted from their due process rights and fair trial guarantees. And concerningly, according to our documentation at MENA Rights Group, as well as many of our civil society partners and UN human rights experts, these measures are often imposed on the basis of vague terrorism or security-related accusations, which are brought against dissidents, human rights defenders, and civil society to silence them for their peaceful criticism of state authorities or their human rights work. And as a result, those impacted can find themselves having their assets frozen, their organization shut down, they can be barred from traveling outside their country, be detained for indefinite periods, and they can even find themselves stateless. So to tackle this critical topic, MENA Rights Group has organized today's discussion by inviting expert panelists from the UN and civil society to bring a human rights perspective to this issue and to shed light on the human impact of these administrative measures. We will be hearing from Ben Sol, the UN Special Rapporteur on Counterterrorism and Human Rights. The Special Rapporteur has recently presented his new thematic report on this topic to the UN General Assembly in New York in October. And unfortunately, the Special Rapporteur being in Sydney, Australia, he was not able to join us live due to significant time difference. So we will be playing his pre-recorded video intervention. And we will then continue the discussion by hearing from three human rights experts on the region who have joined us today. We will be hearing from Nadej Lahmar, Algeria researcher at Amnesty International, who will be touching upon the human rights impact of administrative counterterrorism and security measures in Algeria, including the imposition of travel bans against human rights defenders and dissenting voices. We will also hear from Jawad Fayrouz, chairman and founder of Salam for Democracy and Human Rights, an NGO working to improve the situation in the Middle East and to preserve the universal principles of dignity and respect for shielding democracy and human rights. And Jawad will be speaking on the rising practice of citizenship stripping in Kuwait and Bahrain. And last but not least, we will be hearing from Hamad Al-Shamsi, Executive Director of the Emirates Detainees Advocacy Center, or EDAC, which is an NGO founded in 2021 by a group of human rights activists to support and shed light on the cases of detainees of conscience in the United Arab Emirates, or UAE. And Hamad will be speaking on the practice and the impact of terrorism listings against political dissidents in the UAE. So this webinar is being live streamed on MENA Rights Group's social media channel, and we will be opening the floor to questions from our online audience. So if anyone has any questions during the discussion, feel free to add them as a comment. The event is also being recorded and will be accessible to watch back on MENA Rights Group's YouTube channel. And on behalf of MENA Rights Group, I'd like to thank the State of Geneva for their generous support in making this event possible. So without further ado, we will start with UN Special Rapporteur on Counterterrorism and Human Rights, Ben Sol's intervention.
Good afternoon. I'm pleased to join you from Sydney. I thank the MENA Rights Group for hosting and for its persistent advocacy against human rights violations in the MENA region. My latest report to the General Assembly addresses the global proliferation of administrative measures to counter terrorism outside of the criminal justice system. Such measures profoundly affect many human rights, but often have wider and vaguer thresholds and fewer due process and judicial protections than under the criminal law. Too many governments have rampantly abused them, including to stifle civil society, human rights defenders, journalists, and political opponents. My report focuses on four very common administrative measures. First, restrictive orders, such as limits on movement, communication, association, and civil and work rights. Two, the listing of individuals and organizations as terrorist, whether to freeze assets, criminalize behavior, or ban travel or movement. Three, administrative security detention. And four, mandatory interventions to prevent violent extremism, which attempt to coercively reform an individual's behavior, expression, and opinions. In the MENA region, all of these measures have been widely abused. Terrorist listings have been notoriously imposed on political movements, journalists, human rights defenders, and civil society organizations in countries like Egypt, Turkey, the United Arab Emirates, Algeria, Iran, and Israel. In Turkey, even using social media has been regarded as proof enough for a terrorist listing. Recently, the decision by the United States to sanction three leading globally respected human rights organizations from Palestine as part of its campaign to undermine the International Criminal Court's work on Israel is alarming and represents a direct attack on international justice. Sanctioning organizations for documenting, exposing, and denouncing human rights violations is a blatant violation of the rights to freedom of expression and association. These organizations deserve to be supported and funded precisely because of their work at this time on Israel's atrocious violations in Gaza and the West Bank. The ICC sanctions follow counter-terrorism sanctions imposed by the United States on another Palestinian human rights organization which promotes and protects prisoners' rights. Sanctions and designations are being misused in an effort to silence pro-Palestine voices and hinder international accountability. It's part of a pattern of transnational repression of advocacy for Palestinian human rights, including the United Kingdom's ban on the direct action protest movement, Palestine Action, and United States sanctions on International Criminal Court personnel. Israel is also currently proposing legislation against the ICC and has previously sanctioned Palestinian human rights organizations. Administrative security detention has also been widely abused in the MENA region. It's particularly dangerous since it can easily enable arbitrary detention and forced disappearances, torture and cruel, inhuman, or degrading treatment or punishment, and arbitrary deprivation of life. Recent abuses in armed conflicts are testament to these risks. The long-standing concerns about the different Israeli security detention regimes are well known, including arbitrary detention, inadequate due process, torture and ill treatment, and the vulnerabilities of child detainees. These concerns intensified after Israel responded to the 7 October 2023 attacks, including a dramatic increase in deaths in custody, torture, and the notorious conditions at the military's Sdei Taman facility. After 7 October, Israel amended its unlawful combatants law to reduce due process for the thousands detained under it. The law is not consistent with international human rights law and international humanitarian law, since its grounds of detention are too broad, allowing arbitrary detention. Detention orders and judicial review are not sufficiently prompt. Access to lawyers can be denied for protracted periods. There is inadequate disclosure of reasons and evidence and an opportunity to be heard in a reasonable time, and family visits and access by the International Committee of the Red Cross are not guaranteed. Unlawful confinement of civilians is, in fact, a war crime and a crime against humanity. Serious concerns have also been raised in the MENA region about mandatory interventions to prevent terrorism or violent extremism. Examples include the United Arab Emirates' counseling centers and Saudi Arabia's so-called de-radicalization centers, including a lack of legal authority for detention, vague and overbroad grounds of intervention, the targeting of activists and dissidents, denial of family contact, arbitrary and potentially indefinite detention, and lack of due process, including legal representation. There are also inadequate independent judicial safeguards. In order to prevent these kinds of abuses, my report to the General Assembly sets out general principles to guide the responsible use of administrative measures and then provides tailored guidance for each of the 4 measures examined. Given the acute risks involved, such measures should only be used exceptionally and where strictly necessary to prevent terrorism, and they must be proportionate to that aim and be applied on a non-discriminatory basis. They should not normally substitute for criminal prosecution where feasible, or be misused to circumvent the stronger protections of criminal trials. The grounds for issuing them must be clearly defined in law and based on a precise and narrow definition of terrorism that meets international standards. Measures must also be stringently time limited. My report calls for rigorous procedural safeguards, including adequate disclosure of evidence, accessible and prompt judicial review, and effective remedies, including compensation where rights have been violated. Administrative measures must also not be based on unreliable predictive risk assessment tools, including those powered by artificial intelligence. The special needs of vulnerable groups must be taken into account, including people with disabilities or mental health conditions, victims of terrorist groups, and survivors of sexual and gender-based violence. Measures should only be exceptionally applied to children. In closing, I urge all governments in the MENA region to review whether administrative measures are even necessary in light of prevailing terrorist threats, and if so, to ensure that legal frameworks and operational practices accord with international law and the best practices in my report. Thank you.
So we thank Ben Sol for his participation in this discussion and for making this important topic one of his priorities as he holds his mandate of UN Special Rapporteur. So we will now turn to our first round of interventions from our civil society speakers. And I will start by turning to Nadej from Amnesty International. Nadej, could you give us an insight into the current state of civic space in Algeria and the current climate for Algerian dissidents and human rights defenders? And how do administrative measures, specifically imposed in the context of counterterrorism or security, play a role in this context?
Thank you very much, Tanya. Thank you, MENA Rights Group, for inviting me to this event. And thank you to the Special Rapporteur for his intervention. So yes, I will give a brief overview of the situation for Algeria, for civic space, and then in relation to counterterrorism and restrictions to the right to freedom of movement. So overall, in Algeria, what we have documented over the past, I would say, especially over the past 4 years, is a relentless crackdown on civic space, on the exercise of freedom of expression and freedom of assembly, peaceful assembly and association, especially. This crackdown was basically at its strongest over 2021 and 2023, but overall since then. In those years, we specifically documented the shutting down of civic space with the suspension of political parties, the dissolution of prominent civil society organization, the dissolution of media outlets, and we also saw a closing of the space, the physical space for access to peaceful assembly in the country, with the shutting down of peaceful protests. So this was what happened basically over 2021 and 2023. And since then, we have seen that authorities have continued to restrict the exercise of the rights to freedom of peaceful assembly and freedom of association and freedom of expression. So if we look over the past year or last year, we see continued arrests whenever there are spontaneous protests. or the authorities refuse to give authorization for peaceful assemblies, for example, from political parties. The Rally for Culture and Democracy had 2 events forbidden this year. There was also a march, for example, for Palestine that was refused in August this year, for example. We also see, for example, earlier this year, a number of protests that have taken place from students, teachers, and doctors over working conditions. We saw that a number of peaceful protesters were arrested, 2 union members. A strike, the authorities declared it to be unlawful as well. So we see these restrictions, and then of course we see continued widespread arrests on online activists or social media users, using vague and broad penal code provisions. So overall, using vague and overbroad penal code provisions, for example, undermining national unity, or offense against public bodies, are still used very, very widely and recurrently against social media users, journalists, human rights defenders online. So through all these measures, the authorities have maintained really quite tight restrictions on civic space, which is the context in Algeria. And so within that context, we have seen specifically that authorities have repeatedly resorted to vaguely worded and baseless terrorism charges to crack down on peaceful dissent. So specifically since 2021, authorities have been widely using these vaguely worded terrorism charges against HRDs, journalists, activists. The definition of terrorism in the penal code in Algeria was already overly vague, which was highlighted in its last review by the UN Human Rights Committee. But in June 2021, the authorities widened again the definition, incorporating working on inciting to gain power or change the system of governance by unconstitutional means, or undermining national unity as within the definition of terrorism. And they then introduced a national list of terrorist individuals and entities based on a process of designation that was controlled by the executive and security authorities, and that was characterized by several due process issues. For example, the absence of a requirement of the authorities to inform the individual of the designation, the lack of requirement of disclosure of evidence, the unlimited duration of the designation, the lack of judicial oversight, and the lack of an effective right of appeal as well. So this legal framework and the designation process was criticized by several UN special procedures, and they rightfully highlighted the risk of this legal framework being used to impose disproportionate sanction against activists and human rights defenders. So since this broadening of the definition and the creation of this list, we have seen several prosecutions, investigation and prosecution and convictions against political dissidents, activists, and journalists, simply because of ties with the individuals who have been designated as terrorists, or the organizations also designated. So simply for online communications, or liking a specific post online, individuals can now be prosecuted for terrorism charges. This is the case also for journalists who are speaking to sources, including these political activists designated as terrorists. So, for example, we've seen that journalist Abdelwakil Blem, in January 2025, he has been arrested and placed in pretrial detention based on private communications with activists. We have seen recently in October and November also unionist Salim Ameri was sentenced to 15 years in prison, also for these kinds of online communications on 29th of October. On the 11th of November, also recently, another activist, Mohamed Tajadid, was sentenced to 5 years also for also these kinds of communications with other activists that are designated as terrorist according to this overbroad definition. So this has become really a recurrent pattern of this communication used to prosecute people for terrorism, and also the authorities have also been using this new definition of terrorism, and we see prosecutions for people who are calling for political change or criticizing the authorities with a view to try to push for political reforms. These type of criticism and the type of advocacy for political change is now considered subversive or terrorist and now liable to criminal prosecution. So then moving on from that to arbitrary restrictions on the right to freedom of movement, we see that specifically focusing on travel bans, we see that in the Algerian Code of Penal Procedures, a prosecutor may order travel ban for the purpose of an investigation. It's supposed to be for no more than 6 months, or indefinitely until the investigation is closed if the offense relates to terrorism or corruption. So there are several issues with this, including the presumption of innocence, because this is coming essentially from a prosecutor and therefore based only on a police investigation. There's no judicial oversight from an independent judicial authority. There's no clear criteria given in the law for these travel bans. We cannot assess if it's based on legitimate motive, if it's proportional, if it meets criteria of necessity. Also, in the law, the decision is supposed to be motivated, but in reality, the individuals are not necessarily informed. They are not informed about the opening of this investigation, and they are not informed of the travel ban. And even when they chase the authorities, they realize while exiting the country, they are blocked at the airport, they're trying to understand. They are not necessarily provided a motive, a reason for this travel ban. And of course, in the law also, there's no possibility of recourse, of legal recourse, especially as people do not receive a written document with the decision, so they're not able to take it then to contest it. So often the individuals have to chase the authorities to be able to lodge, to be able to get a response, to be able to understand, and then the only recourse often is to lodge a complaint for abuse of authorities, for example. So this has been problematic. And in some cases, even the law mandates that the prosecutor order the termination of the travel ban. But in some cases, the travel ban was not renewed, but also the prosecutor did not order the termination of the travel ban. So individuals are stuck in this gray area, and they are not able to get a clear response on the status of their travel ban, for example. In July, the authorities adopted a new code of criminal procedures. We see that and maintain roughly the same framework for travel ban. However, now indefinite travel bans can be also applied for offense related to state security, which is again very broad. The travel ban now has to be notified to the individual, which is progress, and we hope it is implemented. However, it doesn't mention explicitly it should be notified in writing with an explicit possibility of legal recourse, which is still missing. And the law now asks for the prosecutor to, like, the motivation for the travel ban to come from the prosecutor, not just the police authorities. However, it's not clear if this is going to be shared with the individual concerned, the exact motivation. And again, no clear possibility for legal recourse. Other issues I should mention also is the issue of these like informal travel ban. Again, that people who find themselves banned from exiting the country at the airport, but have no written trace, no information on the opening of an investigation or travel ban decision. There are also issues, for example, with obstruction of passport renewal, or people who have been sentenced or the investigation has been closed, but they haven't been given back their passports. And I should also mention that the travel bans can also come in the form of a judicial supervision measure from an investigative judge. So we have seen in recent years more and more investigative judges for example, mandating a travel ban, but also a travel ban within the country, so forbidding people from moving from their own like regional locality, which is concerning, as it's in the cases that we've seen, it's been applied against peaceful activists solely for the exercise of their human rights. And we have also seen another worrying development is these entry bans. We have seen 2 cases of the last roughly the last year and a half. In April 2024, for example, authorities arbitrarily prevented a Nigerian journalist from entering the country, and they forcibly returned him to France, where he resides, with no motive again provided. And the same thing happened in July of this year with a French-Algerian national and human rights defender, Nassira Dutour, who was again also forcibly returned to France. So this is a very rough outline of the situation for Algeria. Overall, we can see issues that we find overall, wider issue that we find in Algeria with due process, a lack of clarity, a lack of really specificity with the legal provisions, a lack of legal recourse, also problematic with the implementation of legislation, even if the legislation mandates something, for example, the prosecutor to motivate the decision, and it is not applied in practice, and individuals have to chase around the authorities to understand their situation, basically. So this is very much symptomatic of wider due process issues in Nigeria. Thank you. I'll stop here.
Thank you so much, Nadej, for your very interesting insights into Algeria's legal framework concerning counterterrorism and how the increased broadening of the terrorism definition also has a worsening impact in practice. And it was really interesting to illustrate kind of the arbitrary nature of how administrative measures like travel bans or prohibitions of entering the country are imposed, including your description of people finding out they can't travel at arrival at the airport or without being provided a reason or length of the measures. So thank you so much. Jawad, I want to turn to you to ask if you could give us an overview of the current human rights contexts in Kuwait and Bahrain, and an insight specifically into the practice of citizenship stripping.
Thank you, Tanya. I hope my voice is clear. You can hear me, right? Okay, thanks a lot, and highly appreciating for focusing in this webinar over the counterterrorism and how it's impacting the human rights in general. Although the topic is going to be about Kuwait and Bahrain, but I will specify more and focus over Bahrain majority of my talk, because about the Kuwait, somehow it is not directly related revocation of nationality to the Counter-Terrorism Act, but it is morely related to the right of Amir to revoke the nationality. Even it is not related to the nationality law in Kuwait, but we will speak in details about revocation of nationality in Kuwait almost 1.5 hours from now in our joint event with some other partners in details, and we'll elaborate a lot about revocation of nationality, the reasons, the impacts, and the categorization, and how it is really related to the domestic legislation, or it is just being used by Amir and his power to do so. Although it is earlier been announced that it is part of the countering any types of the fake process to gain the nationality in Kuwait, but later on we found out that the Kuwaiti authorities gone beyond that limit and related to so many rights of the women to gain nationality after their husbands who are Kuwaitis and so on. So we have different cases, a lot of cases, and even such decision is contradicting with so many of the Amiri decrees earlier has been issued and led to the naturalization of so many individuals. So that part, I will leave it to our coming webinar, which is going to be almost 1.5 hour from now, and focus over the Bahrain case. It is so usual to justify and try to give any types of the legislation cover of any wrong act by the authorities, and in the same time to go to the extremist sides of the penal code. This type of the counter-terrorism term is being used. In fact, the act is not directed to any terrorists. The act is directed toward the activists, the NGOs, and the politicians who are mainly criticizing the authorities. And that led to so many negative impacts. The main framework of this counterterrorism is based on a legislation being issued. It is legislation number 58, is being issued in 2006. It's called the Anti-Terrorism Act to protect society from any terrorist act. And accordingly, if we specify this particular legislation, we can find so many vague terminology is being used, yet to give the authority whatever way they want to interpret these types of the terminology. And in the same time, even the definition of the terrorism is unclear. Who is terrorist? What act considered to be terrorist? And is such vague term which are being used, is it seriously a terrorist act or not? For example, if we can find out here so many terminologies, I can name few of them. Disturbing public order, that is being defined as part of the terrorist act. But how someone could be accused to be a terrorist if just he is, for example, showing his protest against a certain policies, for example, or harming national unity? Who gonna define that act is harmed national unity and it is seriously harming or not? Or if we can hear sometimes endangering the country's reputation. What types of reputation? How he's endangering? Is he, for example, criticizing a certain wrong economical policies, or they are criticizing certain types of the foreign policies, or they are criticizing the issue related to the poverty in the country? Can it be led to the issue of the terrorism? Is it right? And who gonna define it, and who gonna analyze it on that one? It's all related to the government. And in that regards, they given through this law certain power and certain right to all legislative process, not only the governmental bodies like Ministry of Interior, national security apparatus, and so on, but they given the same right to these bodies to claim such act was a terrorist act, and then accordingly they will act accordingly. I'll give you here examples. If they want to give more power to the public prosecutor to let someone to be under detention before they take him to the court, extend it to the 6 months, easily they will say this act by the accused person was a terrorist act, then he will be taken to the public prosecutor of the terrorist act. Accordingly, the public prosecutor have right to keep him under detention without any trial, without any types of the justifying why so long he been under detention, just because he been trialed in or he been taken in the public prosecutor anti-terrorist persecutor. And then if you're going to take him to the court, to the anti-terrorist court types, for sure the minimum types of the penal code, if they can address to it, he can be charged between 7 and even to the life sentences. We have so many cases. The act was some youth burn a tire in the street to show their anger towards certain actions, political actions, service actions, so on. Burning a tire is considered to be a terror act. Then imagine someone gonna burn a tire, what he will end up, because through this legislative order or law, they given the authorities in the legislation and judges to reach to the level of revocation of nationality. And this is what happened. Due to burning a tire in the street, in so many cases, led to this who've been accused to lose their nationality. led to the revocation of nationality, or just because the authorities claim that you endanger the Bahrainis' reputation, your nationality will be revoked. And that happens. For that reason, since this law has been passed and exactly it's been escalated since 2011 when Bahrain joined the Arab Spring, and then they wanted to target all the activists during that time, we can see how much escalation of the revocation of nationality is continued till it reached more than 900 of the citizens lost their nationality just because they expressed their view, for example. And I am one of these victims. Although my case was not through the court, it was not through any types of the legal process, it was just a decision by Minister of Interior, by my nationality is being revoked, just because I spoke maybe in certain media press and bringing up certain views against the governmental views and so on. Although I was, during that time, I was MP, a member of the parliament. So my national, so this here, the danger is it, how the authority will let themselves through an illegal, quote unquote, process to indicate that the act they done, it was by the law. And that led to the majority of the opposition leaders to be behind the bar and their leaders to be sentenced to life. And at the same time, the escalation of revocation of nationality increased. That led to the further power to be given what been called terrorist courts. So through the terrorist courts, this not required certain types of the appeal and other rights of the victims that they can utilize it to defend themselves, or even the shortened time of the process, which is make it very short, and at the same time not easily the lawyers and solicitors can have access to all the documents and so on. So that escalated a number of detention, escalated number of the court verdicts, and that which lead to thousands of the people to be detained, and majority of them considered to be quote unquote as a terrorist, although the majority either they expressed their view or they joined a peaceful assemblies in the street or some gathering and so on. So this type of the process, if we go through a certain times of the timeline, we can see that 2006 the law started, 2011 Arab Spring, and then they engaged as much as they can through these types of the law, and then they targeted the most active political oppositions, which they've been banned, and after the banning them, the detention of the leaders then led to the total political isolation, where the majority or all of the members of this banned political parties, they don't have basic political or civil rights. They cannot vote, they cannot make any types of the nomination of any coming election and so on. And then a major political suppression is being engaged on through a certain campaign. Surge and terrorist trials and citizen revocation, as I said, the number reached 990. With the international condemnation, it was huge international condemnation. It is against the international conventions, against the treaties that Bahrain already signed on. So they took a little bit a step back. In April 2019, the king reinstated almost the half of those nationalities been revoked. Out of almost 900, 551 reinstated, but still we have 435 still their nationality is being revoked. But in summary, I will end it up here to say, in Bahrain, anti-terrorism law have been widely criticized. This is my indication for being applied to activists unrelated to anything related to any terrorist act, particularly peaceful politicians or peaceful political activities or civil actions. The impacts included restrictions on civil liberties, weakening of political pluralism, erosion of the judicial fairness, and international reputational cost, which is, we can see that this is wrong act is being used and misuse of the terror act by the authorities. I will stop here, and maybe after during Q&A, I can make more comments. Thank you very much.
Thank you very much, Jawad, for sharing your very interesting examples of the vagueness of the acts that could be, deemed as terrorism at the discretion of the authorities, while they can actually fall under fundamental freedoms protected under international law. And thank you as well for shedding light on the gravity of the impact of the implementation of these laws in practice, including, as you mentioned, citizenship revocation and the personal impact this has also had on you. So thank you very much for sharing that. And thank you as well for sharing about your upcoming webinar on Kuwait a bit later, and we invite everyone to join that as well. So Hamad, I'd like to turn to you now to speak on the context in the UAE. So I wanted to ask you, what is the current state for, freedom of expression, civil society in the country? Can you give us an insight into the practice of terrorism listings or any other administrative measures that have been imposed in the context of counter-terrorism and security?
Yes, thank you very much, Tanya, for having me, and thank you for MENA Rice for organizing this webinars. Maybe I would like to start actually by sharing side news that we received today, which is the death of one of the prisoners of conscience in the prison yesterday. And this prisoners of conscience has been detained in 2012. And in 2013, he has been sentenced to 10 years in prison in the UAE 94 case. And he was supposed to be released in 2022. However, the UAE government decided not to release him, but rather to put him on a new trial with the same charges, but this time under counter-terrorism law. And he has been sentenced to 10 years just last year. He passed away yesterday. I do not want to go into details of the situation and the condition of the prisons inside the UAE. Maybe it is not the topic of today's webinar. But when I actually received the news, I had mix of feelings, to be honest. It likes feeling of sadness and frustration on the same time. Because, I mean, we have been advocating for the prisoners, for the release of these prisoners for almost like a decade. And we have not succeeded in doing so far. And when I just got the news, I mean, I asked myself what we have been doing wrong. I mean, are we evaluating our mechanisms right? I mean, are we using the right mechanism? Why we are not having the right enough pressure on the government to release these prisoners of conscience? Why we let the governments to use their tools, to use their power to keep this prison for a while? I know this is not the topic of today's webinar, but I just want to shed light on this. Maybe later on we can just discuss it in more details. And maybe we need to evaluate our mechanism, to be honest with you, UN mechanisms, our mechanisms. We do not want to spend off efforts on something that we will not have a result at the end. So maybe this is something that we need to discuss in more details among human rights activists and human rights groups. Yeah, having said that, I would like to go back to today's topic, and maybe I would like to start with something personal. I left the UAE in 2012, and a year later, almost in 2013, I was sentenced in absentia to 15 years in the case, in the UAE 94 case. Then almost 9 years later, to be more precise, on the 12th of September 2021, I wake up to find my name placed on the UAE national terrorism list. So I remember that day very clearly. I remember asking myself, why now? Why after 9 years, the UAE government remember me to include me on their national terrorist list? And the only thing that came to my mind that on that year, we established EDAC, the Emirates Detainees Advocacy Center. And we believe that the move of UAE to include me on that list is because we started EDAC. We started a new human rights work. And that's tell us very clearly that peaceful human rights work in the UAE is treated as a threat people defending basic rights are labeled as a terrorist, even though everything we do is public, peaceful, and even it is according to international standards. And it is not only my case. I mean, we today, as I speak to you right now, there are a lot of respected human rights defenders like Ahmed Mansour, Dr. Mohammed al-Rukn, and Dr. Mohammed al-Mansouri. They are serving very lengthy prison sentences, like 15 to 25 years in a prison under counter-terrorism. So these laws supposed to target a real security threat. And instead, the UAE government, or maybe even like it is not only the UAE government, maybe most of the governments in the region, they are using these laws to silence peaceful activists like Ahmed Mansour and Dr. Mohammed al-Rukn. And maybe when you check out the UAE terrorism list, you see the same pattern. The list always include peaceful individuals and civil society groups, even from outside the region, who are not considered terrorists by their own government. The decisions of UAE to include these in terrorist list is clearly political motivated. So it is driven by political need. For example, during the Gulf crisis with Qatar in 2019-2018, many Qataris were who simply spoke against the UAE were added to the list. And when the crisis ended, their names were quickly removed. So this is clearly politically motivated. Another example is CARE, a registered organization in the United States, is also listed in the UAE National Terrorism list. And CARE has nothing to do with the UAE, has nothing to do with terrorism. But the only people who are attacking CARES in the United States is IPAC. And the UAE wanted to police this lobby so they can have more influence and connection. So they listed their enemy in the UAE National Terrorism list. So it is clearly politically motivated. And you know what happens when you mix peaceful activists with real violent groups? You damage the entire counter-terrorism system. You weaken trust. You confuse the public. You undermine real security efforts. People in the region today even joke that if someone is added to a terrorism list, that means he is probably a good person. Like even myself, when I have been added to the UAE National Terrorism list, a lot of people have said to me, Hamad, mention that in your bio. This is in your bio, in your Twitter bio, because this is a compliment. This is not something you need to be ashamed of. This is very good sign that you are a good person. I mean, this is what they're saying. So imagine how much credibility a counter-terrorism system has lost for people to say that. So the situation becomes even worse when there is no independent judiciary in the UAE. So I cannot challenge the decision of the UAE in front of fair court, or I cannot stand before an independent judge to clear my name. Once you are labeled forever. I mean, you cannot just remove it. And, you know, maybe a lot of people undermine this. I mean, they're saying, okay, it is only a national terrorism list. So it is not really a big problem. But in fact, it is a big problem. A lot of people I know, not myself, but a lot of people outside the UAE who have been also labeled as terrorists by the UAE government has their European bank accounts closed because the UAE considered them as terrorists. And these banks do not know the mechanism. They do not understand why these people has been added to the list. So to be on the safe side, they just go and, you know, close their account. So maybe what is the solution? I mean, how can we challenge these kind of things? I believe UN has a big role to do. And unfortunately, UN is not doing their role as from my understanding, or maybe the mechanism that the UN has is very weak. We need to strengthen the mechanisms of human rights, of UN human rights. So I believe that we need to, I do not know how to achieve this, to be honest with you, but I believe that countries should not have unlimited freedom to create their own terrorism list. I mean, we know that terrorism has a global definition. So why we allow every government to have their own terrorism list? Because they always will target their enemy. And we are considered the enemy of the governments in the region. Since we are like on the opposition side, since we are criticizing their policies, then since we criticizing their actions, the government would like to revenge from us, so they will put us on this kind of on this kind of list. Yeah, I do not. Maybe I will stop here, and if there is something that maybe I need to elaborate on, maybe I can take it in the QA session. Thank you very much.
Thank you very much, Hamad, for sharing about the reality of the current human rights context in the UAE for Emirati human rights defenders in the country and in exile, and for shedding light on the UAE 94 cases and also the personal impact that you've enjoyed. So thank you. And I think that the question you posed on reevaluating our advocacy methods and the functioning of the UN human rights system, especially when we're faced with lack of meaningful change, especially regarding the very sad news you shared with us at the start of your intervention. It's a very important and relevant question, so I hope we can come back to it shortly. I will turn to the chat to see if we have any questions, but so far I don't see anything. So I wanted to maybe follow up actually on that question that you kind of posed, Hamad, on the need to maybe reevaluate the mechanisms that we engage with as human rights workers to try to advocate for for meaningful change. I want to ask you, the three of you, if you have any thoughts on this. Currently, what are your main routes of advocacy, or how do you engage in trying to advocate for reform? And if the UN human rights system, as Hamad mentioned, is one of them, how do you see it being improved? If you have any inputs on that, that would be great. I don't know who would like to go ahead, Hamad.
Okay, one part I think good that we can shed about it. The sequence of this fake claims by the authorities that someone is a terrorist, and they try, as we indicated, deliberately to proceed with any types of the judiciary process. Unfortunately, there is wrong cooperation by the international community with these demands. One clear example is the Interpol, and this is impacting a lot over many who are in diaspora. It will limit their travel and they let them to be much fair and so on. It happened a lot. And this is one part of the misuse that deliberately the authorities try to do. Is enough to create any fake case against those activists abroad, and then they try to accuse him that he done a certain types, as Hamad indicated in the details, that they are terrorists and so on, and then easily they can proceed with the court to have certain verdicts, and so quickly they circulate his name on the many either allied country with them, or at least they will circulate his name on the Interpol list. For sure, we are so much aware that Arab Interpol, it is a security entity more than to be like international types of the observing the law and targeting those who are terrorists. But international Interpol, here is our questions: why they should accept such claims so easily and then cooperate. Another major issue, and this is my last point, that why the international alliance of these countries, especially the Gulf states, don't practice their right to try to criticize, and the same time to try to impose certain international regulations and try to let them to stop such a wrong way targeting the activists and claim they are terrorist act and so on. And I think that if they are so much firm and they are serious to stop such wrong act by these states, these allies, they have so many ways, so many powers to let them stop. And unfortunately, due to their political interests, due to their economical interests, military interests, and the security interests, they try to be like blind eyes over this wrong act done. I am blaming a lot these international allies of these states. In the same time, unfortunately, because UN mechanism is not that much powerful to stop it, and then try to, instead of being silenced, at least they should clearly condemn these states why they are, accusing wrongly these activists, only just to control their activity, at the same time to try to damage their reputation, and at the end they want them to control them, to don't make any types of activism. And unfortunately, yet we can see it's working. So many activists, they stopped to travel, they stopped even to appear in the social media and so on, because they are either they're going to be in danger, or they know that their family going to be in danger later on. So I think this totally, as Hamad indicated, a serious act to be done, and that is part of the UN and UN mechanism to be dealt with.
Thank you so much. No, absolutely. And I think we also had a comment in the chat. I think I will try to expose it, from Algerian human rights defender Zaki Hannash, who also shared some thoughts and explained that, authorities in Algeria often accuse activists and opponents of terrorism to damage their reputation, isolate them socially, and because people fear being associated with alleged terrorists, the targeted individuals and their families become stigmatized and cut off from support. So I think that links to your point of the impact is not only on those impacted, but also their families, their surroundings, for civil society, the climate of fear and self-censorship. So thank you so much for sharing that. I don't know if Hamad, Nadej, you have any other comments?
Can I?
Of course.
Everyone knows that UAE human rights record is very bad. Even the UAE government itself knows that their human rights record is very bad. The whole society, the whole people. But the problem that they end up, to be a member of UN Human Rights Council, how it become, how this can happen. I know this is a political decision. It has nothing to do with human rights, but this has confused the public. When public see UAE and the Human Rights Council, they understand, or they have the feeling, you know what, UAE is doing good in human rights. That's why they have been elected to be in the Human Rights Council. Also, when it comes to COP28, for example, this is something that has been done through the UN human rights members, and how they elected UAE to be to host the COP28, for example. I know these all politically motivated. These are political decision rather than human rights things. But I believe that here the role of UN rapporteurs, the UN mechanisms, the UN groups, they have to have a say in these kind of decision. They have to raise their concerns, and they can stop the UAE being elected, or any other members being elected to be a human rights member, a human rights council member, if they have not the green light from all rapporteurs and all working groups. Because I know that a lot of rapporteurs have requested to visit the UAE, but they have declined. Their request has been declined. So the UAE, for example, so I'm taking UAE as an example here, UAE is not cooperating with the mechanism that they are, oversight. So they are oversee the mechanism, the UPRs, recommendations, the visit of rapporteurs, but on the same time, they are not respecting these kind of mechanisms. So how they going to be elected? So my suggestions, I have said it before, and I will say it one more time, that the rapporteurs, the working groups, have to have a role on this. Say they have, like, let's say, a veto role. they can say, no, we cannot allow UAE to be a UN Human Rights Council member unless they do blah blah blah, 1, 2, 3. So this is I think, by having these kind of role by the rapporteurs, by the working groups, I think we will have a better human rights situation on the region.
Thank you so much. Nadej, would you have anything to add? Otherwise, we can move to the final round.
I guess in terms of recommendations for UN special procedures or UN bodies, I think there are a lot of issues with overbroad and vague definition of legislation, security-related and terrorism-related legislation. So I think UN experts and UN bodies play a clear role to really maintain like a straight line in terms of international human rights law, international law. These are the standards, and really maintain scrutiny on that, and really continue to be forceful and communicate to governments and highlight issues, even that might seem not to have a direct impact, but it's very useful then for human rights defenders, for organizations to pick up on and to be able to advocate and push back. And even when the governments respond, they have to justify themselves, and they're aware that there is criticism, or when other governments, also third governments, cooperate with these governments like Algeria or others on like terrorism cooperation, security cooperation, they're aware that there are actual official UN bodies, UN experts that have made this assessment. So it always gives more authority, I guess, to this analysis, and shows that it's consistent since based on, again, international standards. So it's very important to keep having these analyses and having these criticism and scrutiny, and keep highlighting like HRD's journalists, activists persecuted for terrorism is very problematic. So yeah, I think UN bodies do play a key role, and we hope they can continue.
Thank you so much. And yeah, I wanna ask you all as well if you have any concluding thoughts. Do you have other recommendations to UN bodies, as you mentioned, but also to states or even to civil society from other countries, regarding these administrative measures that we've been talking about, citizenship revocations, terrorism listings, travel bans, but also maybe more generally about this clear pattern of, the abuse of security or counter-terrorism laws that are consistently overly vague and broad. And as you mentioned, at the international level, there is still no clear definition of terrorism. So do you think, a root cause here or a root issue that we need to tackle through this angle? And yeah, I'm curious to know your thoughts about this. I don't know who would like to start. Go ahead. Thank you.
Okay, now it's clear that although the total objectives of counterterrorism to maintain security and stability in this planet and in the different regional area, although all of us agree on this objective to be achieved, but unfortunately the current analysis of the way of the different states dealing with this case, it is totally being politicalized. Even when they claim a certain country to be defined as a tourist country, it is unfortunately related to the political affiliation, or how the politically is being organized. Is there part of their allies or not? Clear example is Israel, for example. It is so clear is a very, very dangerous terrorist state. The way they are acting in Gaza, the way they acted in Lebanon, the way they acted in Iraq, they were acted in Iran, they were acted through even in Qatar recently, and so on. But as Israel has been listed part of the terrorist state within the definition of the American or White House, never. But we can see a lot of other countries who are opposing the American policy, for example, they've been defined as a terrorist state and so on. So these types of the definitions and these types of the categorization, unfortunately related to the political affiliation to the political decisions more than the actual fact of the who's engaged in the terror act and so on. And here, the role of the UN should be more and more, and there should be agreement that certain standards, certain types of regulation, certain types of the definition, certain types of the evaluation, and that's required a leading role of the UN and independent experts to refer to. It's not enough a certain state will make its own category and own list and then define activists to be as a terrorist and so on, and they add them, and not it is just adding their names, it is so many impacts over their basic rights. As Hamad indicated, easily your banking account will be blocked, easily, or wherever you travel you could be detained, easily even some countries you are living in, the basic your services will not be provided. So who given such a state to define it, and then the other countries should obey it? So this is a very, very essential issue. So anything, any action is deferring to the basic human rights principle, human rights conventions, and leading to abuse of their power should be stopped. As we know, there is a clear rejection of revocation of nationality, which could lead to the statelessness. Why such states will given part of their counter-terrorism legislation to be part of the penal code to revoke the nationality if they think, quote unquote, a certain terror act is being done. Never ever revocation of nationality which can lead to the statelessness to be part of any penal code. So these things, I think, definitely we need international community to be serious about it, and they should think, and should be agreement on a certain mechanism to don't let such wrong act due to the security reason from the view of these states to limit the basic rights of the individuals and different communities. Thank you.
Thank you so much. Thank you so much for your thoughts. Hamad, Nadej, would you have anything else to add? Well, thank you so much. Oh, go ahead, Nadej.
No, I know we're out of time. I just want to say again, like for me, the main issues really is about like the due process, really international standards that are already present, already available, that are already accessible to states. We know how exactly, like with framework under which we can restrict human rights. There has been a lot of content produced by UN experts on what the definition of terrorism can or cannot include. And again, we always come back to the issue of legality, the issue of the precision in the text, legislative text, the issue of allowing for legal recourse, legal appeal, informing people, judicial review, all these aspects that form like really a clear system of like human rights protection and rule of law that UN experts often keep reiterating. So I think this is available to states, and we hope that states like Algeria, UAE, and others can, if they want to, hopefully use the standards that are available to them to improve human rights and protect human rights.
Thank you so much. All right, well, thank you so much, Nadej, Jawad, and Hamad for taking the time to take part in this discussion today and for sharing your really interesting insights. I hope this is only the start or the continuation of our conversation and our partnership to advocate for meaningful change. And we thank again as well the Special Rapporteur for his intervention, to the State of Geneva for making this important discussion possible today, and to our online audience, thank you for attending as well today. As I mentioned, the webinar was live streamed and will be accessible to rewatch on MENA Rights Group's YouTube channel. And if you're interested in reading further information on the topics we discussed today, feel free to look at the websites of Salam, of EDAC, of Amnesty, and MENA Rights Group as well on our websites. Yeah, thank you again to everyone, and have a pleasant evening.
Thank you.
Thank you.
Thank you.